Again, welcome to our 650 webinar, Updates to Cal OSHA's Emergency Temporary Standards. My name is Ryan Parker. I'm the Vice President of Legal Product here at 650. And with me on the webinar today are my colleagues, Marie Kulbeth, who is our General Counsel, and Adrian Jack, who is the Director of Legal Product at 650. Let me just go through some preliminary matters and then we'll launch right into the content of our webinar. First, we're excited to answer your questions and we hope this will be an interactive webinar. We'd ask you to put your questions in the Q&A button. Use the Q&A button for your questions. That's located at the bottom of your screen. That will allow us to answer those questions either in writing or live on the webinar. We'll try to answer questions as they come in to the extent we can, but we may also reserve some questions for the end. We're going to have a question and answer time. And so we'll do what we can to answer all of the questions. If there are questions that we don't have time to answer during our webinar, we'll send out answers following the webinar. Speaking of the follow-up email, after the webinar concludes, we will send each person who registered for the webinar an email that will include both the slide deck and a recording of this webinar. So you'll have all the slides and you'll be able to watch the webinar as often as you'd like. Okay, with that, why don't we launch into our webinar today again, updates on Cal OSHA's emergency temporary standards. Let me give you a quick overview of what we're going to cover on today's webinar. We're going to start with the Cal OSHA Stakeholder Meeting. It was hours long. They covered a number of topics, and Adrian Jack's going to help us to kind of go over what came out of that meeting. One of the major developments was penalties, and Adrian's going to talk about that. Then we'll turn the time over to Marie to discuss exclusion pay and the FAQ updates around exclusion pay, which were detailed and have some nuance. I'll then touch on some of the other updates that we got in a recent FAQ from Cal OSHA, and we'll talk very briefly about some tools that can help you to comply with Cal OSHA's emergency temporary standards. With that, I'm going to turn the time over to Adrian so she can talk to us about the stakeholder meeting. Adrian.
Thank you. On December 18th of last year, California's Occupational Safety and Health Standards Board, which we call the board, held a stakeholder meeting. This was a 5-hour meeting right before the holidays, so I'm sure it was a riveting meeting. The purpose of the meeting was to explain key provisions of the emergency temporary standards, which came out at the end of November of last year. We refer to them as the ETS. So the purpose was to explain the ETS to the public and then establish a focused agenda for a future advisory committee meeting to consider amendments to the ETS. This was not a formal rulemaking meeting, but it was an open working meeting where participants were able to propose specific clarifications or improvements to the ETS or ask questions. And then the board, after the meeting, established a focused agenda for an advisory committee meeting that we're yet to see. Many of the clarifications discussed in the stakeholder meeting were incorporated into updated FAQs about the emergency temporary standards. And we'll talk about those updated FAQs, some of them in detail later in this webinar, but we still have many questions remaining after that stakeholder meeting. So some of the concerns raised in the stakeholder meeting are stakeholders raised concerns about the cost of complying with the emergency temporary standards testing obligations. So the ETS require employers to provide testing to employees who are exposed to COVID-19 in the workplace and to test employees if there's an outbreak or major outbreak, and those are defined in the ETS. Employers are required to provide testing. So stakeholders raised concerns about the cost of these testing, as a single test can range between $120 to $180. So an employer that's required to test 100 employees will be spending at least $12,000 to test employees to comply with the ETS. And many companies, this is a concern that may drive them out of business or cause them to shut down facilities if they have to retest employees. Similarly, if there's an outbreak, employers are required to provide weekly or even bi-weekly testing, depending on the severity of the outbreak. So it would cost a large business that has 5,000 employees about $800,000 for 1 week of testing. So just 2 weeks of testing would be $1.6 million cost to that business. So this is a concern to a lot of companies in California. Similarly, Stakeholders raised concerns about what to do if there are circumstances or industries where physical distancing required under the ETS simply is not possible. Cal OSHA acknowledged that these circumstances or industries may exist, but they said that there are no categorical exemptions to these physical distancing requirements, and the burden of proving that they can't physical distance is on the employer, and it's a case-by-case basis to show that physical distancing is not possible. We're ready for the next slide. So as a result of this stakeholder meeting, on January 8th of this year, Cal OSHA updated the COVID-19 Emergency Temporary Standards Frequently Asked Questions. We refer to them as the FAQs. So Cal OSHA added 38 new FAQs, which more than doubled the number of FAQs relating to the ETS. So we really got a lot more information that is helpful, but of course, questions still remain. And then again, just earlier this week, Cal OSHA again updated the FAQs and reorganized and retitled them so they look a little bit different. And then we also received 2 additional FAQs about testing employees with COVID-19. So we're ready for the next slide. One of the biggest takeaways from the stakeholder meeting is that Cal OSHA indicated that through February 1 of this year, so another week, that they will still cite employers, but they will not assess monetary penalties for violations of the ETS that would not be a violation of another Cal OSHA standard that was in place prior to November 30th, 2020. So these other Cal OSHA standards that might be in place would include an employer's injury and illness prevention program or their respiratory prevention program. And this brief reprieve from penalties that we have another week of only applies to certain situations. So if employers are abating, if they've already been cited for a violation related to the ETS, they do not have a reprieve from penalties. And they also does not apply to imminent hazards. So there are some exceptions to these penalties, but we only have another week of reprieve before we start seeing penalties in full force relating to the ETS. So Cal OSHA has 5 different categories of penalties based on their severity. The classification of the penalty determines what the associated penalties will be. So the first rung of penalties is regulatory, and these are violations that relate to record keeping and posting requirements. So for example, an employer that was cited for improperly maintaining records related to COVID-19 would be a regulatory penalty. General penalties are violations that have some non-serious relationship to the safety and health of employees, such as an employer cited for not providing effective training to workers on the employer's COVID-19 procedures. The next classification is serious penalties. These are violations with a realistic possibility that death or serious physical harm could result from the actual hazard created by the violation. Given the seriousness of COVID-19, many, if not most, violations related to COVID-19 are classified as serious. And these are so we think that violations of the emergency temporary standards are likely to be considered serious citations. And also, if there's a violation found by Cal OSHA that is substantially similar to a violation issued in the past 5 years, it will automatically be classified as serious. Willful violations are violations where the employer either knew that what it was doing was a violation or was aware of unsafe conditions and made no reasonable efforts to eliminate them. These are very severe, and we've seen very few of these penalties, as we'll talk about in some of the following slides. And similarly, repeat penalties are repeated violations of the same citation. These are also rare, as employers are trying to mitigate these citations and correct them as soon as possible. So as I mentioned, the type of penalty determines the maximum, the type of citation determines the maximum penalty that can result. So regulatory or general penalties, you'll see a maximum penalty of about $13,000. Serious penalties, which are a lot of the COVID-19 and emergency temporary standards, have a maximum citation of $25,000. And repeat or willful violations, which are very severe, have a maximum penalty of around $132,000. And keep in mind, these are maximum penalties per citation. So an employer that is investigated by Cal OSHA often receives an average of 3 citations per investigation. So you could look at, if you have 3 serious citations, you could look at a maximum penalty of $75,000 for a single inspection or investigation by Cal OSHA. Cal OSHA publicly posts the information relating to COVID-19 violations, and they started posting these on August 25th of last year. And there's about a 2-week lag in what we're seeing posted on their website. So we have information through January 6th of this year. The website by Cal OSHA shows the date of the citation, the company name, the industry code, the classification of violation, a description of it, and the proposed penalty amount. So a lot of this information related to these citations is publicly available, and you can see what companies are being cited for, a specific description of what happened, and then the proposed penalty related, which is a very helpful insight as we're looking at possible penalties companies may face. So of the citations we've seen since August 25th of last year, the vast majority of them are considered serious violations. You'll see 55% are serious violations. So we're anticipating that when penalties associated to the ETS start applying next week, that they will likely be in this, many of them will be in the serious category. And there are also regulatory violations and general violations as well. But you'll see there are very, very few willful violations, and we haven't seen any repeat violations posted by Cal OSHA so far. And you might recall that when AB 65 came out last year, Assembly Bill 685, its application started in January of this year. And one of the implications of AB 685 was that it eliminated a 15-day notice period to issue these types of citations. So prior to AB 685, when Cal OSHA planned to issue a citation in the serious classification, it first had to provide a form to the employer with 15 days notice prior to issuing a citation. But now these citations can be issued immediately. So we're seeing a significant ramp up in the types of violations and the number of violations that Cal OSHA is reporting. So here are some of the trends that we've seen so far. If we can go back a slide, sorry. Here are some trends that we've seen related to Cal OSHA and the citations. So starting in August, when this information was posted, most companies only received about 1 citation, and the penalties amounts were only about $5,000 per employer. So total was about $90,000 in penalties proposed by Cal OSHA. September, the citations increased, so employers receiving 4 to 5 citations per investigation, and penalty amounts went up to about $15,000 per employer. But by October and November, the penalties were as high as $60,000, $70,000, $80,000, even $100,000. And then in December, you'll see a huge skyrocket in the number of citations and the proposed penalties. I mean, they had doubled prior to any previous month. So we're expecting, based on this trajectory and the expiration of that relief period where Cal OSHA would not assess penalties for violations in the ETS that's expiring next week, we can expect to see significant citations and penalties starting in February. So the amount of penalties that we're seeing is based on the number and severity of citations, but here's kind of a rough estimate of what we've seen so far. And remember, when looking at these amounts, employers can, these are the proposed penalties from Cal OSHA, but employers can appeal these proposed penalties. So the final amount assessed to the employer might actually be lower than the amount assessed by Cal OSHA, but that information is not posted. All we know is the proposed penalties. So these are the proposed amounts, but might not be the actual final amounts that employers had to pay for penalties. So total penalties we've seen relating to COVID-19 from Cal OSHA are 2.5 million so far. And we expect that number just to go up significantly. The average penalty amount assessed per company is about 22.5 million. The median penalty amount per company is about 13.5 million. We've seen penalty amounts as low as $475, which is, you know, as far as the severity could go, a company I bet would be pleased with that outcome. We've also seen for one investigation, a company being assessed penalties of $108,000, and that was for a company that was not properly maintaining records related to COVID-19, not communicating the hazards of COVID-19 to employees, and not ensuring physical distancing was maintained in the workplace. The maximum amount per one employer then this employer is Kaiser Permanente, has several locations and several different investigations, but so far Kaiser has been assessed penalties of almost $500,000 for penalties related to violations of COVID-19 standards and requirements. So the penalties can be severe, and these are a great concern for companies. So that's why compliance is of great concern. The citations related to COVID-19 come from a variety of sources. Some come from an accident or fatality that employers are required to report to Cal OSHA, and then Cal OSHA opens an investigation as a result of those accidents or fatalities, while other investigations and citations come from an employee or customer complaint. So you'll see that the majority of these inspections come from complaints coming from employees or customers or other sources. Some of these investigations come from accidents, and very few come from a planned inspection related to Cal OSHA. So as you've seen, the penalties are severe, and Cal OSHA did give a short reprieve, but we're expecting them to come in full force relating to the emergency temporary standards. So employers are quickly and rapidly trying to get fully compliant before that February 1 deadline. So I will now turn the time over to Marie to talk about some exclusion pay information.
Thanks, Adrian. And we did have a few questions come in through the Q&A that we answered there. So again, as we're going, if you do have something come up that you'd like to ask, please feel free to put it into that Q&A channel. So under the ETS, if you have employees who are excluded from the workplace because of quarantine protocols, you do have the responsibility to continue to pay those employees and provide benefits to them if they were both able and available to work. So that brings up a number of questions and issues regarding, what do you have to pay them, what benefits are and aren't included, and, which employees does it actually apply to. So we're going to work through all of those over the next few slides. One of the first things to keep in mind is how long would this exclusion pay be available to employees? The answer to that is that it's for as long as the quarantine period, which can be for up to 14 days. Under the FAQs, it specifically says 14 days, but we also do have executive order in 8420, which has come out, which may shorten that period because it allows for quarantine periods to match with CDC guidelines. So that can change, but the maximum amount according to the FAQs would be 14 days. And along these lines, keeping in mind with what Adrian was just talking about with fines and penalties, also keep in mind that if you are not honoring exclusion pay requirements, that Cal OSHA has been given the authority to both cite companies for that and to order abatement so that the pay would be paid back after they did their investigation. So exclusion pay is required. However, there are a number of situations in which employees will not be eligible for the exclusion pay. And that also means they wouldn't be eligible for the required maintenance of benefits. So employees are not eligible for exclusion pay if their exposure was not work-related. And we're going to spend a whole slide talking about what is work-related exposure. So if their exposure was not work-related, exclusion pay does not apply. If they're unable to work because they have COVID-19 symptoms, they're also ineligible for exclusion pay. And if they're unable to work for an unrelated reason, that's something other than protecting your other employees from possible workplace transmission, then exclusion pay would not apply. So as I mentioned, you have to determine if their exposure was workplace related. There is a presumption that exposure is workplace related. It's a rebuttable presumption, which means that the employer can make the case that it was not a workplace related exposure. To do that, you would have to go through the investigation process, which you have to do under the ETS anyway, anytime that you do have a potential workplace COVID case. So first of all, keep in mind, if you have an employee who tells you they have COVID exposure and they've come into the workplace, you are required to take those reports seriously and do an investigation. Ultimately, it's your responsibility as the employer to determine whether the exposure occurred elsewhere or was a likely workplace exposure. So again, like if you have an employee who reports an exposure and you determine that it wasn't workplace related, you could put forth that evidence. You would have to put forth what's considered comparable evidence after doing a comparable investigation. what's not clear from the FAQs is what is meant by comparable. So what we've been thinking and what we would suggest, at least until we get more guidance through new FAQs, is that a comparable investigation to determine whether an employee was actually exposed at the workplace would look the same as an investigation for a COVID-19 exposure in the workplace. So if you're following ETS, you have, got your investigation form that you'll need to fill out anytime that you have a workplace exposure, and you go through a certain process. So if you go through a similar process in order to rebut that presumption that somebody was exposed at work, that would probably meet the requirements for a comparable investigation. The standard of proof to prove that somebody was not exposed at work is more likely than not. So again, like that's a fairly high standard of proof to meet in regards to this type of investigation where, you're never going to, in most cases, have 100% clarity on how somebody got exposed just because of the possibility of being exposed through asymptomatic people, whether it's at work or in another situation that they were exposed. So we do expect to see further clarification on this question, helping us understand in particular, what is considered, comparable evidence, what would be sufficient to rebut that presumption that somebody's exposure was workplace related. So again, if you're trying to avoid investigations, it may be easier and in the end save you money to actually just treat it as a workplace exposure. But there's also the concern that if you have large workforces and a number of people reporting in with quarantines, you may start to really feel the hit of paying exclusion pay. So you may want to do those investigations to do that, to rebut the presumption.
Marie, before we move on to our next topic, there's a question here that I thought I'd just give to you because it touches on what you've been discussing. What does Cal OSHA consider proof that an employee did not contact COVID-19 in the workplace? Do we have any indication of what could be considered proof on that front?
Yeah, that's a great question. And, we don't have much from the actual guidance in the FAQs other than them using that word comparable evidence. But what we can do is what I've sort of outlined on the slide here is, think about what you're allowed to ask anyway in the investigations that you're required to conduct. So COVID-19 investigations, you're supposed to find out, when was the person last in the workplace? What was the date of testing and the possible onset date for symptoms? So, asking your employees those questions as part of your process of the investigation is allowed. You also need to determine, where at the work site might the employee have been exposed or exposed others to COVID. So again, like finding out, which people did they interact with while they were at the work site, going through that process and documenting the answers. All that documentation would be considered evidence that you could submit. And then also finding out whether any other cases have been reported by individuals who are at the work site during the likely exposure period. Now, what you need to remember here when you're going through this investigation process is that, COVID-19 exposure can happen over a number of days that would be considered the exposure period. So for somebody who does develop symptoms, it's most likely that they were exposed 2 days before they develop symptoms, or at least you should investigate at least the period of time, when they came into the office, anytime within the 2 days before their symptom onset. And for people who tested positive but were asymptomatic, they never developed symptoms, it would be 2 days before their positive test at a minimum. You may want to expand that time though, because as you do the investigation, these investigations are going to be based on interviews to a large degree. So you may find out additional information as part of that interview that will help you pinpoint the exposure date more clearly. But at a minimum, you need to do those 2 days prior to the test, 2 days prior to the onset of symptoms. If you can find out the date when they believe they were exposed, so maybe they got tested, on a Friday, but they believe they got exposed on Wednesday because, they heard that, so-and-so in accounting had COVID and, they saw so-and-so that day. You can try and pinpoint it more specifically. And you can also do this through the use of your regular screener questionnaires. So as you're screening employees before they come into the work site, you can use the information submitted in the screener if you're maintaining that information as evidence that you could submit as part of your proof that they were not exposed in the workplace. So, if they're reporting no exposure, no symptoms on the daily screener, and then, they uh, they have an onset of COVID symptoms, and you can show that during that time period, no one else at your workplace was showing symptoms, nobody else reported any sort of COVID exposure. Again, it could decrease the likelihood, but meeting that standard of more likely than not is something that we haven't yet seen anybody um, give us guidance on how to meet the standard in a more specific way. Um, so keeping that in mind, um, we need to, in addition to going through the investigation, you also need to know which benefits they're eligible for at which point. So that would take us over onto the next slide. And this is sort of one of the most common questions that we see, which is this differentiation between workers' comp and exclusion pay. One of the things that is really important to take into account when you do exclusion pay is that you're allowed to offset exclusion pay by other benefits that the employee receives. So if an employee is, for example, receiving some benefit through paid family leave or another, maybe they receive something from, the state through disability, you're allowed to offset exclusion pay by those amounts. However, there's some situations where it's impossible for employees to be eligible for certain benefits and exclusion pay at the same time. And the most common one there is your temporary disability benefits. So if somebody is on temporary disability, it means that they've lost wages because they're unable to work due to their disability. But with exclusion pay, one of the requirements is that the employee is able and available to work. So the disability automatically excludes them from exclusion pay and makes them eligible potentially for disability benefits. And the opposite is also true. If somebody is eligible for exclusion pay, it means they must be able to work, which means they're automatically ineligible for disability benefits. So keep that in mind. If you have somebody who's claiming both, they're likely eligible for one or the other in most situations, but they can't be eligible for both at the same time. So sorry, we're just going to stay on benefits for a second longer. So keeping that in mind, a few other things just to, make sure that you're taking account for is, okay, if you're doing the offsets, that's allowed with exclusion pay. But in addition to wages and benefits, you also need to keep in mind that if somebody is eligible for exclusion pay, you also have to maintain their status. So say you have a floor supervisor who goes on exclusion pay during their quarantine period. And when they come back, they still need to maintain that status as a supervisor. So that is another main difference between a lot of other um, employment regulations that you'll see.
Marie, we have a question related to exclusion pay in the Q&A. So if an employee has to quarantine multiple times and has used up maybe all of their employer paid sick leave, does the employer need to continue to provide exclusion pay for each quarantine period, or is it limited?
You definitely need to provide exclusion pay at least for 14 days. So, you can require that they first use their leave, their sick leave, and then go to exclusion pay. So the answer is it's not clear whether once you've worked through all of the sick leave and then worked through 14 hours of exclusion pay, whether if another quarantine occurs, you have to again provide an additional, up to 14 days. That wasn't specifically answered in any of the FAQs. Certainly, I would say in most situations, the hope would be that you would at that point, either needs to do a couple of things. If this has happened enough times that an employee's worked through all of their sick leave and 14 days of quarantine, you may want to examine your workplace policies and procedures, because if they're being exposed at work multiple times and needing to quarantine, uh, there's likely some abatement procedures that you need to put in place to abate the risk at your work site. And you might see other problems coming down the line because of that. If you think it's a situation where an employee is taking advantage, that's a situation where you'd want to start to look at rebutting that presumption that it was a workplace-based exposure. So my feeling is that if it's a workplace-based exposure, you would need to pay exclusion pay um, for multiple subsequent quarantine periods, but that's not clear from the guidelines themselves.
Thank you.
And I will now turn the time over to Ryan, who's going to talk about a few additional updates to the FAQs and also address vaccines.
Thank you, Marie, and thank you, Adrian. Let's start with vaccines. Vaccines are a frequent topic that we see in the news and that people are discussing all over the country, and businesses are no exception. In fact, recently the EEOC came out with guidance stating that, indicating, I guess I would say, that most businesses can require their employees to be vaccinated before they enter the workplace. And so businesses are thinking through vaccination policies, and we at SixFifty have been working on that issue ourselves. And so it's not surprising that in the FAQs, the Cal OSHA addresses vaccines. And a question was posed about whether individuals who receive the vaccine are still required to comply with preventative measures that are required in the ETS. And the answer is an unequivocal yes. They still need to wear masks, they still need to practice social distancing and follow the other prevention measures, and that would include screening measures that businesses have in place. And I think there's a couple of reasons for that. One is that I think we're still learning about the virus and the vaccine, and whether individuals who are vaccinated can still spread COVID-19. And I think as we get more information on that front, that's something that could change. And so I think this is an area where we're likely to see some movement. And Cal OSHA in their FAQs indicated this very thing. In fact, they said that the ETS will likely be revised in the future to address the impacts of vaccines. And so I think we're likely to see not only Cal OSHA, but the EEOC and other federal and state agencies address vaccines as they become more widely available. And as businesses start to grapple with the need to decide whether to mandate vaccines, whether to encourage them, or whether not to address them in business policies. And so that's certainly an important issue, and one that we'll be watching to see further guidance from Cal OSHA. The next thing I want to discuss is the testing requirements. And I want to go back to something that Adrian said at the beginning of our webinar about the potential costs of testing employees. So let's, keeping that in mind, look at an employer's testing obligations. So first, an employee has to inform, or an employer, excuse me, has to inform all employees on how they can obtain testing. And that's simply a requirement that an employer provide information. Second, employers have to offer testing to an employee at no cost and during working hours in the event of a potential COVID-19 work-related exposure. And I'll just draw your attention to the word offer testing. This became a point of confusion that was clarified in the FAQ, because in the next bullet here, employers also have to provide periodic COVID-19 testing to all employees in an exposed workplace during an outbreak. And finally, testing must be provided in a manner that ensures employee confidentiality. And so with these obligations in mind, employers had a number of different questions about how they were to, well, first, whether there's a difference between offering testing and providing testing, and how they were required to provide testing. As Adrian said, hiring a third-party company to provide testing can be extremely expensive. And so here are a couple of the answers that we got in the new FAQs. First, offer and provide have the same meaning. There's no distinction there, although early on there were some questions about that. Second, and I think this is an important point for employers, employers can send their employees to free testing sites, but must pay the employee for the time spent being tested and traveling to and from the testing site. Employers should also reimburse employees for travel expenses. So in California, every county has locations that offer free testing. And so employers can take advantage of those free testing sites and have their employees tested at those sites to meet their requirement that they provide or offer testing. And that really, I think, is an important clarification because it takes a potentially enormous financial burden off of employers who may have thought that they needed to contract with a third party or they needed to provide testing on site. They can actually have employees who fall within the requirements of the ETS go to county testing sites. They just need to pay them for the time and reimburse them for the travel expenses. Let's look at a couple of other issues that we have here for testing, and I want to just touch on one in particular. Employers who looked at their requirements wondered what happens if they provide or offer testing to their employees, and then their employees decline or refuse to be tested. And I think that could certainly put an employer in a difficult position. And in the FAQs, OSHA has explained that an employer doesn't violate the ETS if it offers the testing, but an employee declines or refuses to take it. So I think that's helpful in that, the verbs offer and provide mean that the employer just has to make those available. It's really up to the employee to decide whether to take the test or not. Second, employers are not required to obtain a signed declination form from employees who refuse to take a COVID-19 test offered by the employer. And there was some thought that if an employee declined to take a test, that there would need to be some sort of documentation in a signed declination form. That may be a good practice, but certainly OSHA has said it is not required. So where does this leave employers if they have an exposure and they're required to provide testing, for example, at the workplace to an employee who was potentially exposed, and that employee declines to be tested? Well, I think that in a situation like that, an employer would be required to exclude the potentially exposed employee from the workplace. Under the rules for OSHA, that time period can be 14 days. And under recent amendments, where OSHA adopted recommendations from the CDC, that time generally can be shortened to 10 days if the individual has no symptoms. But if an individual is tested, that may not be necessary. But in that situation where someone is exposed and refuses to be tested, then they certainly would have to be excluded during the entirety of that time. So as we talked about with vaccines and as we've touched on today, one of the things that is particularly challenging about the ETS is initially when they came out, there were a number of unanswered questions. OSHA has taken some initial steps to answer those questions through their updated FAQ. But as we've discussed, there are a number of questions that remain regarding things like evidence in determining whether someone was exposed to COVID-19 in the workplace or outside of the workplace. Certainly with regard to vaccines, OSHA has said there's information that's forthcoming. And so there can be a real challenge for employers as they're not only trying to meet the substantial requirements of the ETS, but then also trying to keep up to date. And so I think there are different solutions that are available. And I want to just touch on what we've done at 650 to try to help businesses to meet the requirements of the ETS. First, we've created a document generation engine that helps businesses to generate the documents that they need to comply with the ETS. A lot of the ETS requirements require the creation of specific documents that contain information related to the business. And what we've done to make that as easy as possible is we've created a very straightforward and simple question flow that will walk your business through a series of questions. It'll then take the answers that you give to those questions and create the documents that you need. And those documents include, as you can see on the next slide here, they include the CPP, the COVID prevention plan, which will be customized based on your answers. There's also a customizable identification of COVID-19 hazards worksheet and a case investigation form. And so using a simple question and answer process, we can help you to create customizable documents that you can use to meet the document requirements of the ETS. In addition, we produce those documents to you in Word so that you can further edit them as needed. Finally, as we touched on, the ETS is something that has evolved since it was issued and will continue to evolve as we get further clarification about the requirements and as there are further developments as we learn more about vaccines and other topics. And so in a situation with such a evolving standard, it's difficult to keep your documents up to date. You could pay an attorney to draft up a CPP that then could be out of date in a matter of weeks as the ETSs are updated. And so what we've done is we've created, I think, a solution to that by sending out updates that explain when there have been changes. In fact, shortly after the ETS was issued, OSHA came out with a change to bring its quarantine requirements. That's the requirement to quarantine after a potential exposure in line with the CDC's updated guidance. California had originally required 14 days, and California adopted the CDC's guidance that there were options for reduced quarantine and now allows people to quarantine for only 10 days. And so that was an example of a change. When that occurred, we went in and changed our documents. We sent out an update, and those who wanted to update their documents could simply go into the document generation engine and generate a new document that had completely updated language that reflected the change. And so we're continuing to do that as these FAQs, for example, come out and make clarifications. We're updating our documents and we're sending out updates to those who purchase the solution to help them to know what's happening in OSHA and specifically with regard to the ETS. So that's one way that companies can tackle this, I would say, substantial burden of complying with the ETS and making sure that they're taking all the steps necessary. And so that's the way that we've tried to address it. We're right on schedule. We'd hope to leave about 15 minutes for additional questions to the extent there are some. And it looks like we maybe have one in the Q&A.
So with that question, Ryan, I'll read it, and then I was thinking we might break it down into two parts. The question is, can a company CPP establish a requirement for testing so that if an employee who refuses to test may not be permitted to report to work? So I thought we might first, for those who are newer to the ETS, explain what a CPP is, and then give the specific answer. Maybe Adrian, do you want to hit the CPP for us?
Yep, definitely. So one of the biggest requirements of the emergency temporary standards are that companies must maintain and provide to employees a written COVID-19 prevention program. And they're which we refer to as a CPP. And there are a lot of very specific requirements that must be included in the CPP. Some of them include how the company screens employees, how the company identifies hazards, but there's a very full list of what must be included in that CPP, but employers must maintain it and then provide it to employees and make it available upon request.
Thanks, Adrian. And then anybody can claim the second part, which is, so can you put into your CPP that employees who refuse to test will not be permitted to report to work?
Yeah, I think this is an interesting question that maybe even goes beyond the CPP, excuse me. Employers can require employees to be tested for COVID-19 before they come to the workplace. And that's something that we've seen a number of employers do that we're helping with our return to work tool set. In the context of the CPP, the requirement that, and we touched on this a little bit, but I think the requirement is only that companies offer testing or provide testing. And so in a situation like that, I think certainly they're not required to have that exclusion, but I guess if you fall into those categories, right, where, for example, you've had an exposure, then you would be required through screening to exclude that person from the worksite, at least for those 10 days. If the question is, well, what if, we want them to be tested outside the context of the CPP and they won't, can we exclude them from the workplace? I think, that's an individualized assessment that you may need to talk to an attorney to talk about your specific situation. It may depend on the nature of your workplace and how much exposure there is and the protections that are in place. But I'd be interested in Adrian or Maria if you have other thoughts.
Yeah, I would add that I know there are situations in which you can put that into your COVID policy. I teach a class at a university, and they have randomized testing requirements that you have to meet. And if you refuse to, submit yourself to the test, you're not allowed on campus during that period. So it's not that they're testing everybody every day, but if you refuse on your randomized day, then there's a period of time when you are excluded from the campus environment. And so it's a combination of, assessing the risk factors at your organization and also assessing any regulatory requirements where, in some situations, there are special regulations in place for certain industries that actually may require testing of your employees and other people using your facilities. Education, higher ed is a specific example of that, where we see more of that type of regulation than in other industries. But there's certainly situations where it would be appropriate and allowed for you to make that sort of requirement.
And a follow-on question is, if you require testing to come back, how do you do this without being able to ask for their test results?
Yeah, Morgan, I think that's a good question. And I think, again, this may be a little outside the scope of the CPP, but it is something that we look at with our return to work customers. And I think generally, because COVID-19 has been identified by the EEOC as a direct threat, that employers can require individuals to be tested and to show that they received a negative result to return to the office. And I know initially there were a lot of companies that have already come back that required all of their employees to be tested for COVID-19 before they returned to the office. And so I think, Morgan, your intuition is probably correct that typically employers cannot ask employees medical questions, but in this situation, asking for the limited information that they have tested negative, I think is generally permitted. But these are, and I think this is maybe where you're going, these are complex issues that you would be wise to speak with counsel about.
Well, it looks like we've wrapped up everything in the Q&A. We might leave it open just for a couple more minutes in case somebody's typing a question right now. Ryan or Adrian, any wrap-up thoughts that maybe were generated by the questions that we did see come in today?
Yeah, I would just add that, I think we've had a lot of questions about returning to work in general that maybe move beyond the CPP. And that's an area that we have been helping businesses with for now much longer maybe than we anticipated because of how the pandemic has stretched on. But we have a return to work tool set that can help businesses to first take an assessment that will help them to determine how prepared they are to bring employees back to work, and will flag issues that they should think through and consider before doing so. They can then generate a return to work policy that includes the company's policy on things like testing, screening, and the like. And then it also has some other tools that you can use, including a screening tool where we're helping a number of businesses with their daily screening before employees come back. And so if you're interested in the return to work tool that we've discussed a couple of times today, feel free to go to SixFifty.com and take a look at that. We have one more question, and this one looks like it's right in my wheelhouse because I've been thinking a lot about vaccines. What if an employee refuses to take a vaccine? That's a big question that a lot of businesses are dealing with, and I'll try to answer it sort of briefly. So the EEOC has said that most businesses, at least businesses that require people to come into the office where people will be interacting with each other, can require their employees to be vaccinated for COVID-19 before returning to their workplace. And so but the government, and I think this would probably come from OSHA on a national level, has not required that businesses mandate vaccines. And so businesses are kind of in an interesting situation where they can either choose to require vaccines, they can not do anything on vaccines, or they can maybe take a middle ground, which is to encourage their employees to be vaccinated. But if, and I think this is where Jeanette's going with her question, if a company adopts a mandatory vaccination policy and they have an employee who refuses to be vaccinated, they may be able to exclude that employee from the workplace. I will say there's two possible exemptions. Employees can ask for an exemption from a vaccination mandate for a disability or medical condition, or for a sincerely held religious belief. And in those types of situations where an employee has asked for an exemption, a business will have to go through an interactive process like they do for other reasonable accommodations and determine whether there's a reasonable accommodation that would allow the person to continue to work. And if that accommodation isn't an undue burden on the employer. But in a lot of situations, I think an employer could exclude from the workplace an employee who refuses to be vaccinated.
Thanks, Ryan. And I'll just say along like one follow-up on the reasonable accommodation language. We recently had a webinar where this came up and we talked about it in depth. If you have an employee who who claims one of those exemptions in the accommodation that they're hoping for is to be able to work remotely, we're likely to see some changes in the way that remote work as an accommodation is viewed by courts in the future. If you have, pivoted and started working remotely and it's proven to be sort of like an acceptable method for your workforce, saying no to that as a reasonable accommodation is going to be looked at a lot more suspiciously than it was in the past. So that's something to keep in mind from just the practical perspective as well.
Yeah, thank you, Marie. That's definitely true. Well, it looks like we have answered all of our questions and we're just about at time. I want to thank everyone who's joined us for our webinar today. In particular, we appreciate the questions that have allowed us, I think, to have an interesting discussion about the ETS and about some return to work issues more broadly. We're excited to be able to work with companies to help them to comply with the ETS and to bring their employees back to the workplace safely. And we hope that you'll join us for future webinars as we continue to host discussions of these important issues for businesses. Thank you very much and have a great afternoon.